Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of criminal procedure, especially matters involving the 12 guidelines issued by the Supreme Court's constitutional bench regarding exercise of powers under Section 319 of CrPC for summoning additional accused during trial. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Sukhpal Singh Khaira versus State of Punjab pronounced on 5th December 2022, FIR was lodged against accused for offence under sections 21, 24, 25, 27 to 30 of Narcotic Drugs and Psychotropic Substance Act 1985, Section 25A of Arms Act and Section 66 of the Information Technology Act 2000. In the charge sheet, 10 accused were summoned and put to trial. Even the second charge sheet did not name the appellant as an accused. Only after the initial recording of evidence, the prosecution filed an application under Section 311 of CrPC for recalling of PW 4 and 5, which was allowed. In the further examination of those witnesses, they named the appellant. Thereafter, the prosecution filed an application invoking Section 319 of CrPC for summoning additional 5 accused, including the appellant. The session judge allowed the application on the same day when the judgment of conviction and sentence was passed against other co-accused. The appellant alleged that the session judge order was not sustainable as the same was not passed in a proceeding pending before it, as at the stage when the power to summon was exercised by it, the judgment of conviction and sentence was already passed earlier. After the regular legal procedure, appellant's challenge against Sessions Judge Court came before the 2 judges bench of the Supreme Court, and they raised few issues, and thus the matters were placed before the constitutional bench to consider the questions raised. The issues posed for consideration are whether the trial court has the power under Section 319 of CrPC for summoning additional accused when the trial with respect to other co-accused ended and the judgment of conviction rendered on the same date before pronouncing the summoning order. Whether the trial court has the power under Section 319 of the CrPC for summoning additional accused when the trial in respect of certain other absconding accused whose presence is subsequently secured is ongoing or pending, having been bifurcated from the main trial. What are the guidelines that the competent court must follow while exercising power under Section 319 of CrPC is the third issue to be considered. The Supreme Court has held that the power under Section 319 of CrPC is to be invoked and exercised before the pronouncement of the order of sentence where there is a judgment of conviction of the accused. In the case of acquittal, the power should be exercised before the acquittal order is pronounced. Hence, the summoning order has to precede the conclusion of trial by imposition of sentence in the case of conviction. If the order is passed on the same day, it will have to be examined on the facts and circumstances of each case, and if such summoning order is passed either after the acquittal order or imposing sentence in the case of conviction, the same will not be sustainable. The trial court has the power to summon additional accused when the trial is proceeded in respect of the absconding accused after securing his presence, subject to the evidence recorded in the split-up or bifurcated trial pointing to the involvement of the accused sought to be summoned. But the evidence recorded in the main concluded trial cannot be the basis of summoning order if such power has not been exercised in the main trial till its conclusion. Further, the Constitutional Bench has issued elaborate guidelines regarding the exercise of powers under Section 319 of CrPC for summoning additional accused during trial, and they are: if the competent court finds evidence or if application under Section 319 of CrPC is filed regarding involvement of any other person in committing the offence based on evidence recorded at any stage in the trial before passing of the order on acquittal or sentence, it shall pass the trial at that stage. The second one, the court shall thereupon first decide the need or otherwise to summon the additional accused and pass orders thereon. If the decision of the court is to exercise the power under section 319 of CrPC and summon the accused, such summoning order shall be passed before proceeding further with the trial in the main case. Third one, if the summoning order of additional accused is passed, depending on the stage at which it is passed, the court shall also apply its mind to the fact as to whether such summoned or accused is to be tried along with the other accused or separately. The fourth one, if the summoning order of the additional accused is passed, depending on the stage at which it is passed, the court shall also apply its mind to the fact as to whether such summoned accused is to be tried along with the other accused or separately. The fifth one, if the decision is for joint trial, the first trial shall be commenced only after securing the presence of the summoned accused. The sixth one, if the decision is that the summoned accused can be tried separately, on such order being made, there will be no impediment for the court to continue and conclude the trial against the accused who are being proceeded with. If the proceeding passed in a case where the accused who were tried or to be acquitted, and the decision is that the summoned accused can be tried afresh separately, there will be no impediment to pass the judgment of acquittal in the main case. The eighth one, if the power is not invoked or exercised in the main trial till its conclusion, and if there is a split up or bifurcated case, the power under section 319 of CrPC can be invoked or exercised only if there is evidence to that effect pointing to the involvement of the additional accused to be summoned in the split up or bifurcated trial. The ninth one, if after arguments are heard and the case is reserved for judgment, the occasion arises for the court to invoke and exercise the power under section 319 of CrPC, the appropriate course for the court is to set it down for rehearing. The 10th one, on setting down for rehearing, the above laid down procedure to decide about summoning, holding of joint trial or otherwise shall be decided and proceeded with accordingly. The 11th one, even in such a case, at that stage, if the decision is to summon additional accused and hold a joint trial, the trial shall be conducted afresh and de novo proceedings be held. The last one, if in that circumstance the decision is to hold a separate trial in case of the summoned accused as indicated earlier, the first one, the main case may be decided by pronouncing the conviction and sentence and then proceed afresh against summoned accused. The second one is, in the case of acquittal, the order shall be passed to that effect in the main case and then proceed afresh against summoned accused.